Welcome to today's remote session. This is Tom Bechtold with Secure World Digital. I apologize for our delay. We were having a little bit of a technical issue on my side. I think I figured it out, so hopefully you're hearing me now. We've got the slides available for you today, as well as a really nice document that kind of spells out what we're talking about here today with the privacy law in California. So you're here with a countdown to CPRA, what information security professionals need to know now. We've got a lot of ground to cover today, and which is usually the case. But I have a couple things I just really wanted to just say about our topic today. Consumers kind of got tired of constantly being hit with marketing stuff, is kind of what I'm feeling. And eventually, legislators actually kind of agreed, probably because they buy stuff too and got tired of being inundated by stuff, and they wanted to get something done. So we had things like the GDPR, which is going to be celebrating its birthday in May, I think 6 years now. That came out of that kind of stuff. And then the state of California, they were like, hey, you know what? We need to do something like this. So they came up with the CCPA a couple years ago, and then that kind of has evolved because they were like, okay, what are we doing with this stuff, right? I mean, they were like, you have the right to know what companies are doing with your data. You have the right to delete it. And then you have the do not share, do not sell, right? So what was happening, though? Was anybody really enforcing any of it? They were, of course, over in the EU. But in California, what was happening? So they came up with a new law that would help us out. So the CPRA was created, and it's going to go into effect January 1st. Now, I'm not going to steal any more of their thunder here. Our guests have a lot more valuable information to share than I do. But I wanted to give you just a little bit of a background on what we're talking about today. So that being said, I have a quick housekeeping slide somewhere in here. I'm going to give you real quick here. Like I said, we've got today's slides. There's a great report in there on privacy from CPRA. If you have questions, we're taking those throughout, so send those in. Use that question box. I'll be trying to get to as many of those as possible. You'll get a certificate of attendance after about 50 minutes. It's a pop-up, so check out for that. Otherwise, you'll get an email later, about an hour or two later, that you can use as well. If you do have any audio or video issues, hit F5 or function F5. That usually fixes most things. And this is being recorded. So if you do have some problems or you get a time crunch or something, you got to bail out, or if you want to share this with a colleague, by all means, that same link you used today, you can use that to return or share that. So we definitely want to try to get many people to collaborate on this stuff as we can. So that being said, who is here today? I've got a group here. Scott Giordano, he is the VP Corporate Privacy and General Counsel for Spirion, old friend of the family. Veronica Torres, she is the Worldwide Privacy and Regulatory Counsel at Jumio Corporation. Orson Lucas, he's the principal over at KPMG. And then last, and certainly not least, a jazz guy that I had to mention that because we were talking about this before on camera or off camera. Tim Morin, he is the CIO and CTO and founder of Media, Entertainment, and Technology. He goes way back in security, so he's going to be giving us a lot of great insights from his angle as well. So that being said, I want to give Scott an opportunity here to kind of set the stage for us, Scott. And our other presenters, feel free to chime in when Scott's done if you guys have some comments as well. But Scott, welcome, sir. It's great to have you back on the program.
Thank you for having me.
The floor is yours, man. Let's hear what you have. I'm eager to hear it.
Wonderful. Well, what we're going to do is we're starting off with some key dates for CPRA. And what's interesting about CPRA is that it both uses a 12-month look back in the sense that data that's in scope for the new law, the data that we all care about, and certainly from regulatory perspective, our clients care about, started on January 1st of this year. And so that 12-month look back period ends at the end of this year, and that data is all in scope going forward. So that's important to know, that essentially all the important information that you want to have control over, that clock already started almost a year ago. So January 1st of the new year, CPRA goes live. And what's interesting about that is now employee data and business-to-business data is now in scope. That was something that was questionable before. It was implied by the law, but the authors of the law, I'm told, didn't envision that employee data or B2B data would be in scope. It is now in scope. Also, the regulations, the CPPA regulations, in contrast to the CPRA regulations go live, we hope, sometime in January or February. They should have gone live already, but such is the case with government agencies. And then July 1st is when the beginning of civil and administrative enforcement begins. And when we say civil and administrative, we mean that both the California Privacy Protection Agency, which I'll talk about in a bit, and the California Attorney General both have the capability to enforce this law. So talk a little bit about the regulations, because this is something that is still somewhat in flux. These are the regulations for the California Consumer Privacy Act, the CCPA regulations. They have been amended twice by the California Privacy Protection Agency, and hopefully will go live in the next couple of months. In terms of regulating and articulating what's important for information security, it's a bit of a letdown. So what essentially the regulations say, not surprisingly, is that the business in question shall implement and maintain reasonable security procedures and practices for whatever is in scope. So that could be in the course of maintaining records about consumers. It could be transmitting personal information to a consumer. It could be the self-service portal that some businesses set up. So the net of it is that the regulations really did not go into any great depth. They simply mirrored this idea of the statute that the business shall implement and maintain reasonable procedures and practices, did not really go into what qualifies as such. So as a consequence, we dig a little deeper here and we talk about how the law itself has changed. So originally the law was couched in terms of information security in the negative. That is to say that the CCPA said that if a business did not implement reasonable security procedures and practices, then it was liable in the event of a breach. Now that's been changed to a positive. It's a positive mandate. So now a business shall implement reasonable security procedures and practices. That's in the red there. That's the controls, appropriate to the nature of personal information. Whenever you see appropriate to the nature, that is an implicit request for a risk assessment. So you both implicitly require a risk assessment so that you can implement appropriate controls. And a couple of wrinkles that I think are really interesting here. One is that now an email address in combination with a password or security question answer is now in scope as something that's actionable. So think about all the times you hear of how email addresses and their passwords, their respective passwords, are made available on the dark web. Now, all of those now are in scope as a breach. Also, the new law talks about this idea of a significant risk business. It doesn't go into any depth about what that is, but it talks about this idea of how a significant risk business is going to be treated differently. That is to say, it's going to have to produce cybersecurity audits. It's going to have to publish risk assessments pursuant to the regulations that will be issued by the agency. That's the California Privacy Protection Agency. So again, TBD, but this is a big change. And this is something that we're only seeing now in the new rights-based privacy laws that are coming online in the new year. Also, there was a provision for a 30-day notice and cure period. That's gone. That was kind of a way to give businesses training wheels, if you will, to comply with the CPA. That's gone. And even if it was still here, this idea that if you somehow clean up after a breach and fix what was wrong, that doesn't constitute a cure. So there's no way to, for example, unring a bell. So the net of it is that this idea of a cure pretty much is gone. One final thing about the CPRA in terms of the agency. So the California Privacy Protection Agency is our nation's first police agency, if you will, just for privacy. The EU's had theirs for a long time. If you think about the Information Commissioner's Office in the UK, or the CNIL in France, or the Garante in Italy, there's these privacy police that essentially can go and enforce the law on their own. They don't have to wait for another authority to do so, which is what we typically do here in the US. We have the Attorney General's office typically will go and enforce privacy laws, or they'll enforce unfair trade practices laws as a privacy law. The CPPA, the California Privacy Protection Agency, is its own independent agency. It will enforce the CPRA. It will enforce the regulations that it's creating. It also has subpoena power. very big deal, something that I have not heard much discussed, but still very important, especially when you now have two agencies that can issue a subpoena. Also, the CPPA can go and get a search warrant, although they would have to likely go through California DOJ to do that. Just by way of comparison here, there's 5 new rights-based privacy laws that are going live this year. Want to do just a quick comparison on the information security side. So you'll find that the respective laws all say more or less the same thing. A business must implement reasonable security procedures and practices. That's the red section. That's the controls that have to be implemented. But then there is this idea that it has to be appropriate to the nature of the data or appropriate to the volume of nature. They use a little bit different words here, but in the same sense that this is an implicit request for a risk assessment. So I thought that was important, that we see how the different rights-based laws approach this, and they all approach it roughly the same way. Also, in terms of mandating risk assessments, a couple of them do that as well. So you'll find that 4 of the 5 new rights-based privacy laws also mandate risk assessments. Sometimes they'll call them a data protection assessment, but it's still a risk assessment. And it's either going to be for businesses that are a heightened risk or a significant risk business, or are engaging in those kinds of activities. So for example, the idea of processing personal data for targeted advertising, that's considered a significant risk. So different states are going to have different views on what's significant risk, which presents more of a regulatory headache for the rest of us. But the net of it is that this is the way of the future. We're going to be seeing all states eventually take this up, and they're going to take it up and request that everyone develop their own data protection risk assessment. If you're familiar with the DPIA, Data Protection Impact Assessment in the EU, it's the same exact idea. It's just the US flavor. Tom, that's all I have at the moment. I'm happy to share the floor with anyone that wants to make comments, or we can go on.
Sure. Any comments from our panel? Otherwise, I've got a couple questions for you. Okay, fine. No worries there. Who does the risk assessment? Is the onus on that business? Does it matter? Excuse me. Who does it? Do they need to hire an outside party that's like, more reputable? How does that work?
They're not required to hire an outside party. They can certainly do it internally. I can tell you from many years in the business that you'll find 2 completely different results when you do an internal risk assessment versus having a third party do it. There's just too much in the way of politics when you do it yourself, so it's better to have a third party. Also, the third party can really, I think, have a different perspective than you would internally. It's just a different pair of eyes working on it. So you're not required to have a third party, but I think it's a best practice.
Hey, Scott, one other real quick question, Tom, if you don't mind. I wasn't able to get off mute quickly enough. Scott, one of the things that you hit on, this is an interesting one. I'm kind of curious here for your personal crystal ball around the dual enforcements, right? So you have the California AG as well as the CPPA that's going to be enforcing here coming into as a practical matter for businesses. To what degree do you see them being somewhat consistent and aligned in what they're enforcing and how? Versus really having, 2, for all intents and purposes, divorced parents that are coming after you asking for different things?
I think that the divorced parents idea is spot on. I think that you're going to see different political motivations for going after offending businesses. And so unfortunately, I think that you're going to have different standards that apply, which is going to be frustrating for businesses. I think that ultimately they're going to have to perhaps aim higher than what's quote unquote reasonable in order to meet those standards. Now, that said, I suspect that the CPPA will be taking the lead on most things, because I get the impression that the AG was not in love with enforcing privacy laws to begin with. They may have fallen in love with it since, but they were not, simply because they didn't have the budget and the resources. So it may be that they defer to the CPPA, but either way, there is a dual enforcement risk. And admittedly, that's true of having the FTC enforce things. So the net of it, I think, ultimately is to raise the bar, perhaps what's more than just reasonable.
And since we're on the topic, I saw a question from Dale. He wanted to know, how do they determine the fines? Is that just like is there something published somewhere where you just know I'm going to get hit for 10,000 or whatever?
Well, there's a formula that is within the statute, and it escapes me now exactly what the formula is. It's per record, and I want to say it was $1,500 max per record, and that may have been doubled or tripled if it involved. Go ahead.
If I can chime in,
yes,
so
please.
The penalties under CPRA actually depend on whether the act is negligent or if you were purposeful in that mistake. So per offense, it's $2,000 per offense, and that is per record for individual offense. And then if it's a negligent, it's $2,500. But if it's willful offenses, you're actually going to be going up to $7,500 per willful offense.
That's true. Also, if it involves children, I believe that the dollar value is $7,500 per record as well, if memory serves.
Interesting. Appreciate that. Thank you. Great question, Dale. Let's move on. We have our resident security expert, Tim, waiting in the wings. Tim Morin, CIO, CTO, and founder of Media, Entertainment, and Technology. Tim, come on down. Let's hear your perspective. What's kind of keeping you awake at night thinking about this new privacy law or regulation coming out of California?
Well, I'll go ahead and kind of jump right into the cybersecurity implications here. Just with a note, and some of it Scott already covered, but I'll go ahead and kind of repeat it just for a moment. The California Consumer Privacy Act, of course, went into effect on 1/1/2020, and the California Privacy Rights Act is actually amending that. So it's not really a new law, that's my understanding, and I'll let the lawyers kind of go into detail on that. And then, also as Scott mentioned, that it established the CPRA. So from a security standpoint, the requirements are really essentially the same as the current CCPA requirements, with one big notable exception. And as mentioned, that's really around the kind of the reasonable security procedures and practices that Scott mentioned, and then the ability to have an audit, and something where you have to have a cybersecurity audit, and then also, whether you're going to handle this internally or not. So one of the things that there isn't at this point, and I don't know that there will be, is any kind of a CPRA cybersecurity certification where you go through a process and you get certified, and then you just update that certification on an annual basis. I haven't heard of anything like that happening. But in terms of like the general security and how it may affect companies, if the company is already covered, or if they've implemented a well-defined cybersecurity framework, and some of those would be the CIS critical security controls, which is Center for Internet Security, or the ISO 27001, if they're SOC 2 certified, or if they've implemented the NIST cybersecurity framework, which again, the cybersecurity framework is not something that's a certification. It's simply a framework for building out cybersecurity, and these I would consider to be baseline. Right. So if you have those, then probably from the CPRA standpoint, you're probably in pretty good shape, especially since they are referring to it as reasonable security and procedures and practices. So if you're not there yet, some of the areas that you can focus on, and I'm just going to kind of go through a list of some of these 15 key areas. Certainly my recommendation is multi-factor authentication is an area for all critical systems. It would include networks, software as a service, messaging, cloud, VPN, and any administrative access. And so what you're thinking here in terms of cybersecurity, protecting consumer data, if you apply the same standard to consumer data that you would apply to intellectual property or to financials, I think you're going to be in really good shape as far as the CPRA goes. Also, implementing single sign-on enterprise-wide for all applications that support single sign-on certainly would be a best practice. And it's critical that you have cybersecurity training for all your employees. That would cover phishing and ransomware, social engineering. I would also include, maybe separate from that, but equal to that would be privacy training. Especially with regard to the CPRA, it's real critical that the employees know when they're handling data what they can and cannot do. And then it's important also to have well-documented policies and procedures and standards for computer usage, how users, employees are allowed to use the data handling, standards for networking and firewall configurations. Also critical is enterprise-wide endpoint protection and then remediation. And so that's really antivirus software, anti-malware software. And then also I would dovetail that in with the training, right? So understanding, what not to click on phishing emails and doing tests for that. And so all of this is really, if you kind of think of it in terms of security, this is really these are the basics that you should be doing anyway. You should have automated operating system and application patching, to limit vulnerabilities within your networks and on your systems. Endpoint encryption for all laptops and desktops. And then encryption for all data in transit. So if it's whether it's on Wi-Fi or wired networks, that data should be encrypted when it's at rest or at the database level. And then also for backups. Companies should have vulnerability and penetration testing. Vulnerability testing is like scanning software that will scan the network. It'll identify all the devices. It will identify maybe patch levels on those. It'll look for open ports and vulnerabilities on those, and it'll generate a report. It's generally not terribly intrusive. It can be, but it's not like penetration testing, which is very intrusive. That's where you take that information, and then you would have someone go in and do a pen test where they would really try to hack those systems using those vulnerabilities. Intrusion detection and response. And then also something that's really critical. And by the way, all these are also critical for getting cyber insurance. I would also add cyber insurance as something that would be key if you do run into a problem or there is a breach, and you have concerns around CPRA and what that breach means. Having cyber insurance would also be something that you should have. You need to have a detailed incident response plan. And that also needs to be something that you test, and that would be internally. But you should also have a third-party partner to support you in the event of a breach. And I would say that probably a minimum of once or twice a year with a third party, you would want to do what we call a tabletop incident walkthroughs, where you actually, this is a breach, it's happening in real time, how are we going to respond? This will be with attorneys, it'll be with the marketing department, it'll be with executives. This is not just an IT thing. This is a company thing, which kind of leads us into, what is our business continuity plan? You have to have a business continuity plan in place. I think that this would all be part of the package that as you report to the CPPA for an audit, you'd probably want to be able to include these in your package. And then also disaster recovery, and then logging and monitoring of all systems. So all of these are just good practices to have in place from a security standpoint. But if you're protecting your data, you're protecting your financial data, you need to protect the consumer data in much the same way. And so now I'm going to kind of switch over from the CISO hat to the CTO hat and look at the product management piece of this. As we know, and as has been mentioned, we have this notice of collection, which is required at the point of data collection. And then we have the notice of right to opt out for sale and sharing of personal information. And then the notice of right to limit use. Well, those notices are great, right? Pretty easy to handle. The real challenge becomes, how do you handle the requests for those items? And while not specifically a security issue, there is a security implication here. Because if someone files a request or submits a request to make a change, you have to validate that that person is who they say they are, right? You can't have someone go in, make a claim to make a change, and then have them actually change somebody else's data. Now, the kind of the side on that would be if the person is under 13 years old and you're a parent or a legal guardian, then you would be able to make that change. So there would need to be authentication and verification of who the person is requesting the cancellation, the deletion, the correction, or to know the personal information or to limit the use. For all of them, you need to be able to verify that the person is who they say they are. And then I think, and this is kind of where I'm going to end it, I think the real problem here, the big challenge for businesses is going to be around data governance. I'm going to give you a scenario, and this is probably a pretty common one with kind of medium to large companies, is you have a consumer go to your website and they enter their information online. And all they're doing at this point is they're completing a purchase. So they enter their information online. It's stored in a transactional database. That gets loaded into a data warehouse. And then that gets exported into a CSV file by marketing. And then maybe someone in marketing takes that file and they send it out to all the marketing managers so that they can support an email campaign. And while they're at that, since they're going to go ahead and they have the data, they're going to go ahead and upload it to Google, Facebook, Instagram, YouTube, Twitter, and all the social media sites, so that they can use it for advertising, targeted advertising on social media. And then maybe it gets exported by the data science team for machine learning projects and for statistical analysis and for analytics. The big challenge there is, how do you track all of that data from one location to another? You have a request to delete. So then how do you delete it in every location? And that's just, so far we're mostly talking internally, but when you have business partners and you have contractors and you have third parties that are also looking at sharing the data, how do you have them deleted? And so that becomes a big data governance challenge. And I think that's going to be, from the business side, probably one of the bigger challenges around CPRA. And that was really all I had on my presentation.
Good stuff. I mean, seriously, to me, I was like, okay, where's he going to go with the security? How is it any different, right? But you still have to do all of the same stuff, but probably a little bit more. So I have a question for you from John in the audience. Let me go over here. Tim, can you speak to ISO 27701, which is, I guess, the privacy add-on to the 2701? Is this an important goal for CCPA or GDPR compliance? And by the way, they love your guitars. They also have a guitar acquisition syndrome. So.
Oh, do they? Yes, I'm afflicted. I only have, I'm pretty sure I have at least 3 in this shot and another 10 in the room. So I'm with you on the guitar piece. I really don't have a lot of expertise in that, and I only really came across that particular ISO recently. And but I would say that if you are compliant with that certification, then you would be in really good stead in terms of CPRA, right? And certainly in terms of GDPR, right? So I mean, I don't have any specific.
Hey, this is Veronica. I'm happy to speak to the 27701. I actually helped my last organization certify against it. 27701 is a set of controls. So it's not necessarily are you compliant with CCPA or even GDPR. It's more, do you have the control in place to be compliant? I think one of the things that takes, it's a great foundation. So it creates what is a privacy information management system, the PIMS, which is a supplement to your information security management system, your ISMS, and it adds in the additional controls that you would do. It does speak in terms of controller versus processor, where the CCPA has different types of language, right? We talk about businesses, service providers, third parties, contractors. There's all these definitions under the CCPA that might not map one-to-one to 27701, but you can definitely use it as a really great foundation to meet that control. You would still need an additional internal mapping of the legal requirement to the control itself. For example, there is a control to have a person responsible for privacy management within your organization, and so you'd have to kind of map that to, is that a DPO requirement under GDPR, or what type of mapping does that really occur? I think it's a great tool. It's not an important goal, I would say. It's really kind of what your organization needs in that moment. It does take a lot of work, right? You have to put the controls in place, you've got to do your gap assessment, and then you have to go through the certification process. It's also 27001 is necessary for you to go forth and get your 27701 because it is in addition to your ISMS. So it can't stand alone in that space, but it is a great tool. Again, not necessarily a goal for compliance. It is, your compliance should be really based around the particular needs of your business and meeting the requirements within that law, not necessarily just having the framework in place.
All right, and thank you. And I do want to point out, I am not an attorney. So you definitely have much better experts in this regard on this webinar.
Thank you, Tim. Appreciate the assist, Veronica. And Veronica, you're kind of up, so I'll just kind of shift the slide. Veronica Torres, the Worldwide Privacy and Regulatory Council at Jumio. You're up. Let's hear from you for a bit.
Thank you. And Tim, you kind of stole my thunder a little bit in terms of access and deletion rights, but we'll go through those a little bit. I heard you say, you have to make sure that you have a verifiable consumer request, I believe is what it's called under CCPRA and CPRA. And absolutely, you have to be verifying the identity of your users, but it has to be proportional. So if the only thing you're doing is collecting emails for a marketing list, and that person wants to delete their email, there is guidance out there that you don't have to necessarily check that person's ID. You do have to do sort of a proportional analysis of how much more information do you want to be processing to verify that person's identity, as well as what is the level of security and privacy controls that you need to have around that information. So I'll start with that. But if we can go to the next slide, the focus of my next couple of slides is really, there's so much privacy in these laws because they are privacy laws. So I wanted to focus on what security and IT professionals really need to respond to and be aware of. The first is going to be retention. The business shall not retain a consumer's personal information or sensitive personal information for longer than the purpose it was collected, right? So there are exceptions to this, but I think it's a really important one. We see this with data minimization principles in GDPR and similarly situated laws. And this has not generally been a generally accepted principle in U.S. privacy, but you're seeing it more and more, and you're seeing it with not only CCPA and CPRA, but with FCC enforcement as well, where you are really looking at your data. Why do you still have it? Why are you still keeping it? Really questioning. I really enjoy adding to my product review cycles a request for them to tell me how long they're going to keep data. It's especially important when you start to look. I heard, data governance is going to be super important. Absolutely. All those new data sources need to have a retention period. You need to be able to track them, log them, and understand where your data is located and how you have processes in place to delete that data when it's no longer purposeful. And there's always a line, right? Your business is always going to think that data is useful. The more data you have, the more usefulness that you can get out of it, right? That's the business line you'll hear left and right. And it's important to push back, I think, on that perspective. Do you really need data for 25 years? from a security perspective, you also have data for 25 years. You're securing it for 25 years. You're increasing your threat surface substantially. The longer you keep data, the less you know about your data and where it is and how long it's being kept for. That's when you sort of start to hit upon a few mistakes, and you want to make sure that you're able to really hone in on that, know where it is, know how long it's retained, and where you don't need it anymore, delete it. It's a security issue. It's a cost issue. Are you keeping things in S3 buckets that have been there for the entire lifespan of your company that you're just sending all of your money to Amazon or AWS? It's a constant assessment. So I think with the CPRA requiring you to really look at your retention periods, it's an opportunity to clean up anything that you have out there that you don't necessarily need anymore. And then the next slide, Tim already mentioned, so those access and deletion requests. You've got a couple of different ones here. You've got the right to know, and you have data deletion, and you have access as well. Or right to know is access, sorry. So under access, you've got two different types. You have a disclosure for specific types of personal information, and then you have a disclosure for the categories of personal information. So if you think about it, people want to know, do you know my name, or what's my name with my email address? But then they can also request, what types of data do you have about me, which is a little bit broader. And while there might be some exceptions to providing people with specific pieces of information, that verification process really comes into hand. If you can only verify to a certain extent that person's individual, but there's more sensitive data of verification for, if there's minors in. Also, CCPA and CPRA include sort of the concept of a third party, or I can't remember the exact term that they use, but there's an authorized third party to ask, so an agent, someone that you authorize with that respect. You can ask for categories, and I'll note that in the event the company refuses to provide you with specific pieces of information, by default, you then have to provide that individual with the categories of personal information. So you do have to be very kind of clear on CCPRA or CCPA requests, what you're giving to those individuals, and know where the exceptions are. There are limits to that, which is great, and making sure those limits are and how you can maybe exclude certain types of data, especially information with the purpose to harass, communications with in-house and external counsel, things like that, you can always accept under CCPA and CPRA. Deletion is not absolute. It depends on the types of information. It also depends on whether or not you are subject to other sector-specific laws. I see a question as to whether is consumer data applicable to healthcare. I would say it depends. Are you talking about data that is subject to HIPAA, in which case it's excluded from under CCPA and CPRA. However, if you're talking about healthcare sector but non-PHI as defined under HIPAA, then you could be subject to CCPA. I'm thinking about, CVS or other pharmacies who are collecting consumer data but are not acting in that capacity as a business associate or a medical service provider. So you do have to understand where your business is, what type of data, and then if there's any laws that supersede that. I think GLBA is another example that kind of exempts your data from that. And so knowing what is very important there as well. There's other types of exclusions as well for access and deletion in terms of limiting sensitive information. What types of sensitive information are available? This is always a fun one because I think a lot of companies have a misunderstanding internally or just across somewhere where people don't really understand the concept of sensitive information from a privacy law perspective. So just going through with it, what is it, where do we have it, helping them just understand it is really having that baseline. For example, we think of healthcare data as sensitive because it's about healthcare, but again, if it's not PHI and it's merely what insurance provider you have, that's not sensitive information as defined by the law. So you have to understand the definition of the law and then go forth from there. If we can go to this next slide. So a couple of just like readiness things from my perspective of these particular things. It's always really great to see if you have any tools in place to do these access and corrections. Whereas under CCPA and CPRA, you actually have to have 2 methods for individuals to contact you. Do you have those methods? Do you have even just an email that people can, that you can send to? Sending out an email internally to your company. If you receive a CCPA request, send it to this inbox, and one person will be responsible, or a team will be responsible for making sure it gets to the right people. And then also opting out, and if there are certain parts about opting out of the sale or opting out of the sharing, I do think those fall more on your legal teams and your privacy teams to really understand the sale and share of personal information. But it's important as IT professionals and security professionals to understand what that scope is as well, because when it sort of encroaches upon that data governance, and that you need to know what you're doing in order to be able to comply with the law in this space specifically. And I think that's it for me.
Excellent, good stuff. Actually crossed off a couple of the questions I had since you covered them, so thank you for that. I'm going to take the questions at the end, so I'm going to let our next presenter go, because we're kind of going a little long, but I want to get to these questions. There's a lot of great questions that are coming in, so if you have one, send it in. I'm going to try to get to all of them if I can. So that means we're going to probably go a little bit long. So, but anyway, let's bring out our final panelist, last but not least, Orson Lucas. He's going to talk to us a little bit about this deadline that's kind of looming above us here, if I'm not mistaken. Orson, take it away.
Thanks, Tom. I appreciate that, and out of respect for everyone's time, I'll try to stick to at least the time I had allocated here and keep it relatively brief. So, really I guess the main point that I'd underscore here is the deadline's looming, right? January 1st is very, very quickly around the corner here. So, yeah, I think just as a practical matter, you may be somewhat limited in if you've not started down this path yet in meeting your obligations here by the end of the year. I think a lot of clients started working toward the beginning of this year, and still in some cases have had some challenges there based on the size and scale of the obligation. So with that, though, what I really wanted to underscore, and frankly, the good news here, because there's a lot to consume, especially if you don't live and breathe in the space every day. The good news is, I think that that there's some things that sort of clearly stick out, at least to me, as areas we'd recommend prioritizing. And if you are limited in time, just sort of start to think about some of these and prioritizing these even into early into next year is probably prudent. So I really have about 5 or so that I'll run through kind of quickly. Some of these are going to sound somewhat familiar, maybe underscore what you heard from other presenters, and in 1 or 2 cases, maybe just be highlighting areas that we haven't dug into a lot of depth on yet here. First and foremost, I think you've seen and really heard that that this is a very sort of data-driven set of expectations. So everything from the updated individual rights that people have, sort of the expectations around being able to operationalize those and other aspects of the law really require clear visibility into your data environment, which includes things like data mapping, data discovery, et cetera. So that becomes increasingly important with things like sensitive personal information. So if you've already gone through an inventory and a categorization effort for sensitive information just personal information under the CCPA or the GDPR, really extending that out into sensitive personal information, categorizing and classifying that appropriately, and treating that in accordance with the additional obligations that you have there as well. The second point that I make is that while it's not only about the tools that you use to help to support compliance, it's going to become increasingly difficult, I think, to get by without technology solutions. So, when you think about the scale of requests that may be coming in as you extend out to employees, B2B requests, as well as the consumer requests, in addition, extending that out to the different types of individual rights as well that you heard here a moment ago from Veronica. It's really going to be increasingly difficult, I think, to try to scale that in a cost-effective way. So as an example, there's a tech client that I work with that had in the hundreds of thousands per month of requests coming in. This was earlier this year as well, so this was just under CCPA, but trying to think about doing that in a manually intensive way, right? A request comes in, you email that to a system owner, and they go through and run some manual queries. That's not a scalable thing. It becomes beyond the full-time job for a team of people. So bringing in tools is really important. But I think the flip side of that is it's not just about the tool either, which is a lot of times, people will procure, they'll implement a tool or stand up a tool in the environment, but really thinking about some of the underlying process and governance that wraps around that as well to make sure that you get the value out of the tool is really important as well. The third point, we touched on this in a good bit of depth as well, but I would absolutely agree the retention, defensible deletion, purpose use limitation principles that are outlined are going to be really difficult for a lot of organizations. And for a few reasons, right? One is, I think it becomes really important because regulators are increasingly taking notice around this. So we've seen an uptick in enforcement around this, really across industries, but most heavily probably in the financial services industry recently. It's hard, right? Secondly, it extends not only to structured data, but also unstructured, semi-structured, which is typically a lot more difficult for companies to nail down. And retention schedules that a lot of people have relied on historically might not really be enough anymore, right? So it's this fundamental business shift from what are we collecting and using and retaining? Does that align to the commitments that we made in our privacy notice? And then are we deleting that information when it's no longer required for the defined business purpose? It's a dramatic shift and may require not only some business education, but really some process engineering and redesign as well to accommodate. The fourth area, this is one that we didn't really go into a lot of detail on here, but I think if you follow the news recently, you've probably seen some increased chatter around this, maybe something you're dealing with internally as well. But this idea of an increased focus around cookies and opt-out of sale of personal information. So specifically, the CPRA enforcement action by the California Attorney General recently for about $1.2 million for a failure to cure timely some of the issues that were identified. I'll get to that in just a moment. They immediately followed that up with 120 or so cure notices out to a number of other organizations and basically put them on notice as well in a similar way. So very much making a point and clarifying, I think, some technical points as well around things like what constitutes a sale of personal information, which incidentally isn't just true sale. They extend that out to anything that you're essentially receiving value from, not just dollars back from. Clarification on things like cross-contextual behavioral advertising, but really interestingly, the need to respond to global privacy control signals. So if you're not familiar with what that is, it's essentially, as an individual, you can change within your browser settings, enable global privacy control. And what that does is essentially send a signal to every website that you do business with that says, opt me out, opt me out, opt me out. And so if websites don't have the ability to receive that and respond to that effectively, that's something that is a very visible, bright red blinking light for the California AG as well as potentially the CPPA as well here going into next year. That can be scanned and across a variety of websites. It allows for much more sort of scripted enforcement focus as well, which is kind of a scary thing if you don't have your ducks in a row on that. So would very much encourage you to be on top of that. The last thing I'll touch on here briefly is as well, and this maybe is a little bit of overlap here with the first one, but this concept of automation. So it's really difficult to forecast what kind of volume of data subject requests you're going to get, for example. And that's something a lot of our clients struggle with right now is, do I put in place some kind of an automated solution, whether it's a privacy management platform or a suite of tools like a data discovery tool, data protection, data retention tools. is very much driven by sort of this unknown question of what kind of volume of requests are we going to be getting, and does it make sense to invest in automation right now? My personal perspective is I think with employee requests coming into scope, B2B exemption expiring as well, and probably at least for some short period of time, an increased number of consumer requests that come around this sort of a reinvigorated attention, news articles, things like that are going to come into play. It's very likely to be at least a short-term spike in the volume of requests coming through. So other considerations there that we're actually working through with some clients right now as well. One is where you have plaintiffs' rights attorneys that are essentially collecting and aggregating these requests on behalf of a bunch of individuals and submitting bulk requests, which, it's very easy to respond to one request at a time, but if you have several hundred, it may be difficult to respond to timely if you don't have a good structure in place. The other really interesting one that we ran into recently is a company that has a heavy union component to it. And really this fear that, the union organizers are going to collect and aggregate bulk number of requests as well. So you can imagine if you're sitting on the privacy side of the table, the IT side of the table, and you get a bulk request for 30,000 individuals and you have 45 days to respond to it, that doing that in a manual capacity is going to be just about impossible. So all things to think about there, but really just that concept of automating where you can, even if it's just the workflow around these processes, can be a really valuable thing to help cut down and help to drive some cost efficiency. So I hope I kept to my 5 minutes. It looked like I did, but Tom, any questions, or do we want to open it up to broader questions and Q&A from the group?
Yeah, we've got a ton of questions kind of in general. So I think some of them might kind of go more toward like the attorneys, but let's see what we've got. The first one's going to be a long one. I know the answer will be a little bit longer for this first one. So I'm going to throw this one at Scott. But although the rest of these kind of will do like a lightning round. So kind of a fast, if it depends, that's fine. That's a good answer too. But let's jump in. Chad wants to know, and there's actually several people, but Chad's the one I just highlighted. What is the reality for compliance and enforcement if my business is in another state, but I may have clients, consultants, vendors, or whatever, projects and stuff in California? So how unpack that one for us, Scott?
Sure. I mean, the short answer is that California residents are protected. So even if you have a business in another state, but you have in scope, you have California residents' personal data, and you otherwise meet the standards that the law requires about doing business in California and having a certain revenue threshold, et cetera, you are in scope for enforcement of law. And so are your third parties. This is something that I think kind of got missed in our discussion today, is that there are extensive requirements for contractors and service providers. And as a business, you have to flow down your information security requirements to them as well. They essentially maintain the same standards that you do at a minimum. So the net of it is that absolutely businesses outside of California and in theory outside of the US are subject to CPRA and really need to conduct themselves accordingly.
I like it. Good answer. Next question here is, how would does it make a difference if you're a nonprofit versus a Fortune 1000? I'll let anybody chime in.
Yeah, the net of it is that CPRA doesn't apply per se to nonprofits. There is an exception, I believe, if the nonprofit is acting as a service provider. So generally speaking, if you're a nonprofit as a quote-unquote business, it does not apply to you.
Okay. Let's see here. Okay, that one sounds like the other one. Let's see. That one sounds like the other one. Okay, hang on. Like I said, there's several that were kind of like that first one. Is there a data control or removal requirement for employees that are off-boarded? Let's go with Veronica on that one. So if I get fired or I quit, what happens to my data? Sorry.
It goes back to your data deletion schedule, right? There are exceptions. So California also has some requirements for how long minimum standards for keeping or maximum standards for keeping certain types of data sets. So you're going to want to make sure that you're meeting any sort of record requirements with respect to California employment law. But then you're also going to evaluate, the employees preference for gift giving or just know to keep that for in line, and then create a retention schedule that's proportionate to that, making sure that you're aligned with other employee requirements.
Okay, appreciate it. Thank you. Next question here from Scott is personal information otherwise available in the public domain exempt from CPRA, CCPA? Except for my social security number, I found most of my personal information on the World Wide Web with just a Google search. What do you guys think? I'm thinking more like social media, maybe.
Yeah, please do.
Yeah, just because it's public does not mean privacy laws are not applicable to it. Now, the CCPA has a definition for what is publicly available. So there are certain types of record types that, federal, state, local government records, things like that fall under publicly available. But just because your email is on the interwebs, just because that information is available with does not mean that the business does not have a responsibility to give you access rights to protect it in the same way as the other data that they keep.
Excellent. Okay. Let's see. That one sounds like the other question there. So this was, as I was listening to everybody, and I think Tim kind of laid it out a little bit when he started talking about the certification. But I'm going to throw this out. Anybody feel free to answer this one. Do you think any of these privacy laws or the enforcement agencies, is this going to affect people's cyber insurance? I mean, you kind of have to be doing risk assessments. You have to be doing kind of the due diligence and stuff. Is this going to just kind of tag on? Like if you're getting like too many requests to have your data removed as a company, will that kind of get flagged? And then like the insurance people are going to be like, hey, what are you guys doing over here?
No, I don't see it as a problem for your insurance. I don't, because, and this is, I'm not disrespecting the insurance underwriters. They have a tough job, but they really are not doing all of the machinations in terms of understanding all the various laws and the threats and all the environments and certifications and trying to come up with a formula that works. There's just too many moving parts. So unless you're filing a claim as a consequence of something that really went south, I don't see it affecting your insurance rates. I see other things affecting that, like the war overseas and things like that, but certainly not privacy law related requests.
Okay. And I just want to say thank you to Veronica. I believe she mentioned, just because you can collect the data doesn't mean you should. We've got tons of stuff that we collect all the time, and it's like, what are you even doing with that? Nobody cares about that information. So I really appreciate you saying that, because we got to figure out a way to make things a little simpler, honestly, because we don't honestly need 20 boxes full of information just to find out, where you're going to stay the night at a hotel or something. Okay, that looks like we cleared out most of those questions. There's, like I said, there's a few duplicates there, but I want to give each of our panelists an opportunity, since we're kind of at the end of our time together, to if nothing else, what should people be doing getting ready for January 1st? I should mention they're not actually enforcing stuff until July, but you're still going to be liable for stuff in between that. So as a final thought, I'll kind of reverse order. Tim, what should people be thinking about from the security aspects of this?
Well, I'd recommend, first off, get a real good, solid understanding of the data that you're collecting and where it lives, and really kind of focus on that. And then just in terms of cybersecurity, you're going to protect the consumer data in the same way that you would protect financial data or intellectual property or any other data that would be important to the company. So I think that would be a good area of focus.
Excellent. Appreciate it. Thank you for being here today, and awesome guitars. I'm jealous. I want to just grab one and start playing it. So thank you for that. Let's move over to Orson Lucas. What are you thinking about? What kind of homework or what should folks be doing?
Yeah, as it was probably the one upshot to my my summarization there is I probably hit on all those, but just to kind of quickly run back through them again, right? I think that the top five are, make sure you have good data visibility and control, right? That you understand what all is in your environment. Make sure you've thought about and invested in tools to help to enable and automate things where appropriate. Really think about retention, deletion, purpose, use, limitation, right? We keep coming back to that one, but it's because it's so critical and it's such a sort of a fundamental shift, I think, from what the way a lot of companies have historically dealt with that. And the cookie and opt out of sale piece, right? With the idea that whereas before the triggering event may have had to have been a reported breach or an identified breach, now regulators like the AG, the California AG, the CPPA have tools and mechanisms to almost, if not script, to very kind of quickly and easily go out and probe websites to see if it looks like you're doing the things that you're supposed to do, and use that as a thread to start to pull to unravel. So those are probably the top 4 or 5 things that I'd really focus on there as a priority. And look, even if you haven't really started in a substantial way here, and you're behind behind things a little bit in terms of the deadline, we would still encourage you not to just throw up your hands and say, well, we'll roll the dice, but to really get started in addressing some of those things as early as possible, even if it stretches into early next year.
Appreciate it. Thank you. Over to Veronica. What's your final thought for the audience today?
You have not absolutely started any compliance with CPRA or just weighing into CCPA. I agree with Orson. Go for those low-hanging fruit first. Look at what your biggest area for compliance is, and what I quickly identify as an egregious violation of the law. Fix that, and then go forward and conquer all those bigger items that you need to do, but try to look at the low-hanging fruit first.
Sounds good. And over to Scott. Take us home.
Sure. Your compliance with the law and your protection of the personal data that you have is really going to be no better than your data inventory. So if you haven't updated your data inventory recently, it's probably a very good idea right now to take a top to bottom review and get an idea of just what data you have, where you have it, and who has access to it.
Good stuff. Good stuff. Thank you, everybody. Thank you, Scott, Veronica, Tim, and Orson for being part of the panel today, answering our questions, and really just kind of unpacking this. I think this was a good information for everyone to see and hear. If you did hear something that you like, other privacy folks that weren't here today, share this with them. We got to get more people's heads wrapped around this stuff. If nothing else, asking some questions. So come back and visit us if you need to for that. You should see a certificate of attendance available for you down there in that widget bar. It's a pop-up, so some of you might have that blocked. So shoot me a quick email. I'll get that taken care of for you. But that does conclude today's session. Countdown to CPRA. What information security professionals need to know now? Again, you can share this information with colleagues, and this is available for the next 6 months. So we'll see you on the next round of remote sessions. Have a great day.